Live में बोला जाएगा. Live?
Welcome to Legal Time with Connaughts. My name is Anam Rana. I'm an advocate solicitor with Connaughts, and to my left we have Awais Javed, who would be the solicitor dealing with today's immigration inquiries, as he is an immigration expert. Now, this platform, we deal with a lot of immigration, live Facebook immigration inquiries, and we've received a lot of inquiries online. However, given the shortage of time, we would only be dealing with certain selected inquiries. So, starting with the first inquiry, I would ask Awais Javed the first inquiry that we've received online. Now, a person has said, I have a child who is an EEA national, separated from, the person themselves have separated from a spouse. Now they're asking, can they apply for a derivative right?
Hi, good evening everyone. Welcome once again on Legal Hour with Connaughts. Unfortunately, usual panel is not available today. Sharia Khan had an emergency, so he couldn't come in. But we have Anam Rana with us, like she introduced herself. She's one of our solicitor advocates. Coming back to your question, Anam, first of all, derivative right is a category which is basically based on a case law, Zombrano. This is a category which is generally used when there is no other category available under EEA regulations. We can use this category, but the fact that we don't advise clients to use that category quite often is because this category does not have any recourse to indefinite leave to remain. So you can have your grant of visa, but eventually when child becomes an adult, you cannot extend your visa, which means there is no recourse to indefinite leave to remain. In this category, we will have to show that applicant is the primary carer of the child. Unfortunately, in this scenario, we have a father who has access rights to the child. So father can see the child regularly, maybe we don't know how often, it could be weekly, fortnightly, but father is not the primary carer of the child. Primary carer of the child is mother. So therefore in this scenario we wouldn't advise making application under this category. However, if we can show that child is someone who is maintained and accommodated in the UK by the mother, or maybe father is supporting him, depending whether father has right to work or not, father can also make an application under the immigration rules, and this is something we would advise our clients to. This is the type of route they should take, because making an application under the immigration rules when you have a child who you have right to access, for example, is something eventually that will lead to indefinite leave to remain. So my advice, short answer to the question, if you are not the primary carer of the child, it will be very difficult to fall under this category. And secondly, you will also have to show that if you leave the country, child has to go with you, and child cannot stay in the UK. In this case scenario, child is with the mother, so even if father leaves the UK or European Union, child can still stay within the EU, which means requirements will not be met. So short answer, it'll be very difficult to qualify under this category for that person.
Thank you. Okay, moving on to the second inquiry. If a single mother has a British child, can she apply for derivative right?
I would ask
Well, short answer is yes, she can apply for derivative right. I'm assuming that in this second scenario, the question you have received, mother is not a British citizen, because if she is, then she doesn't need a visa, and she is a European national, she can simply exercise her treaty rights. So assumption, my answer is based on the assumption that mother is not someone who has leave to remain in the UK or is a non-EU national. Yes, she can apply under derivative rights under the same case law, but again it will not be recommended for the same reasons, because there is no recourse to indefinite leave to remain under this category. So I would rather advise her to make an application under immigration rules, get an advice from a good solicitor who can advise her of the requirements of this category, and if application can be made under the immigration rules, then that would be a lot better category for her, because that will eventually lead her to obtain indefinite leave to remain.
Right, thank you. Someone has also asked, is there an alternative route apart from a derivative right?
Well, this is the route where I just explained. For under the immigration rules, you can make an application as a primary carer of a child who's a British citizen in this case scenario. If that is the case, if and mothers generally are the primary carers of the child, of their children, so if that is the case, she can make an application under the immigration rules, and that would be a better category to proceed with rather than derivative right in this case scenario.
Okay, thank you. Now, moving on to another question.
Sorry, Anam, let me stop you here because we are getting a lot of live questions as well with our live feed. So I'm just going to take a question live. It says, how does the parent immigration status affect the 7 years child application? Now, the 7 years child application is probably one of the favorite routes we get questions on every single time. If I have understood, questionnaire is asking if parents can obtain visa if child has reached 7 years in the UK. Answer is yes. Basically, it's a type of category where parents can apply on the basis that they have a child who has lived in the UK for 7 years, and it's not reasonable to remove the child from the UK. So if there is enough evidence to show that child has established enough social ties and it won't be reasonable to remove the child from the UK, then child will get the visa for 2.5 years, and parents accordingly can make an application and get the similar type of visa. They will be entitled to indefinite leave to remain after 10 years because it's a 10 years route, so they will have to apply for an extension every 2.5 years. If child is born in the UK, child can obviously obtain citizenship after 10 years, but if child is not born in the UK, then child will have to finish 10 years in the UK and apply for indefinite leave to remain, and then following on from that, after a year they can apply for citizenship. So this is what I've understood from the questionnaire. There is a follow-up question. If immigration history of the parents is not very good, for example, either they're illegal or they have, let's say, minor offences such as road traffic offences, even serious offences, would that affect this type of application? Well, on that there is a recent case law as well where this parents' adverse immigration history will only affect the best interest of the child, or courts will decide against the child in only in certain circumstances where there are, let's say, multiple criminal offences committed by the parents or one of the parent. Other than that, if there are just minor offences, for example road traffic offences or simple fines or cautions, or they're simply illegal in the UK, then this is not something that should go against the balancing exercise when Secretary of State has to balance proper immigration control against the right of that child to stay in the UK or develop their private life. So I would say that if you have received a decision where, because of the immigration history of the parents, there's an adverse decision from the Home Office, from the Secretary of State, from UKBI, then this is the type of decision you can challenge. There is a case law to back that up in the favor of the applicants.
Okay, thank you.
Okay, I've got another question. It's an interesting one. It says, if both parents have indefinite leave but are unmarried, child was born in the UK but is abroad since the age of 2. Child is 13 years old now and child's foreign passport is expired. What application is needed to bring child back to the UK? So my understanding, child is born in the UK, both the parents have indefinite leave to remain but they are not married. Child is now living outside the UK at the moment. Child is not a born British citizen. Okay, let me put it this way. Child is only a born British citizen if at the time of child's birth parents had indefinite leave to remain. If parents did not have indefinite leave to remain at the time of the birth of the child, then child has to naturalize by way of registration. So if child left the UK or at the time of child's birth in the UK, parents were not they did not have permanent residency, in that case scenario, child needs to apply for naturalization. They need to make an application for registration, and once nationality is granted, citizenship is granted, then child obviously can apply to have the British passport made for travel purposes and can come to the UK. If child was born in the UK and at the time of child's birth, any of the parents, regardless of whether they were married or not, had indefinite leave to remain. In that case scenario, if child is born after 2006, child is a born citizen. Um, in that case, child can apply for a passport. It's an overseas passport application, slightly longer procedure than in-country passport application. Child can apply for that passport, and obviously once passport is issued, child can travel back to the UK. I hope I have addressed both the questions. I have received several requests to answer certain questions in Urdu as well. So if you have any questions you want answered in Urdu, you can put it on our live Facebook page, and we'll be happy to answer it in Urdu as well.
Yeah, definitely. Okay. Moving back to the inquiry selected online.
Yeah.
Can parents who have children, can they be detained?
Very interesting question. I mean, we addressed this, me and Sheriar addressed it last week as well, where we had few weeks back a scenario where a mother who did not have leave to remain in the UK, she was detained while she went for reporting. She had a child who's 7 years old. She also had a child who's, I think, 2 or 3 years old. It was a very different experience, because in my practicing career, I did not see a mother being detained who had young children in the UK under these circumstances, just because she doesn't have a visa. I've seen fathers being detained, but eventually they were released because they had a child. Now, under the new Immigration Act, Home Office has a policy and a department in place. They need to get an approval from that department if they are separating families. If families have children, then obviously the criteria is a lot more stricter. So unless Home Office has gone through the exercise of going through that department, getting the approval for the separation of children of a family unit, they can't separate children from their parents unless obviously there are social care issue or a child's life is at risk. But if they want to separate families, which means detaining one of the parents and leaving children with other parent, then in that case they need to get prior approval from that department. It's a long process. So if that hasn't happened, then obviously detention could be rendered unlawful, and anyone who has faced these circumstances have a good claim. So like we mentioned last time as well, if you have known somebody who has gone through these circumstances, or yourself you have faced these circumstances, then get in touch. We can look into the case and see if we can take this case on with no fee basis as well.
Okay, thank you. Okay. Now, moving on to another inquiry. Is there a visa route available for a person who has access to a British child?
Say that again, sir?
Is there a visa route available for a person who has access to a British child?
Okay, I think it's more or less a similar question we answered in the beginning. If someone has a child who's a British citizen and they don't live as a family unit, then in that case scenario, father can either obtain access to the child by a simple agreement with the mother, or can obtain a contact order via court. Either cases, they can make an application on the basis they have access to a child who's a British citizen, and unless obviously there are any type of circumstances where the application can be refused under general grounds of refusal, generally speaking, visas are granted under 10 years route. In this case, there is another route, which is a 5 years children route available if you can show that they have a requisite English language qualification, they are able to maintain and accommodate themselves. Then they can even go into the 5 years route as well under this category. So yes, there is a route available if you have a child who is a British citizen, not just British. If child is a European national, and you can show that child is self-sufficient, you can still make an application under this category. And get on to a route which can eventually lead to indefinite leave to remain after 10 years.
Right, thank you. Moving on to the next inquiry. Can an extended family member apply for retained right of residence?
Right. Good question. Extended family member, actually there is a case that has come in this week on this topic. It is being decided. Obviously, I thought law was always very clear, but now we have a case law to confirm that position as well. Unfortunately, it's the position that Secretary of State has taken over the years, that if you are an extended family member, then your rights start from the date you were granted leave to remain in the UK. So you were granted a residence card under the EEA regulations in the UK. Before that, even if you have a subsisting relationship with your partner, that will not be counted towards your either indefinite leave to remain after 5 years under EEA regulations, or in case marriage or partnership doesn't last, under retained right of residence. So in that case scenario, if for example someone is in a durable relationship for 2 years, and after 2 years they get married, and they are granted residence card on the basis that they are a spouse of someone who is an EEA national, then from the day residence card is granted, or from the day maximum they got married in the UK, their 5 years period would start towards indefinite leave to remain. Any period that is spent together under even as a durable relationship, even though Secretary of State accepts the relationship is durable, that part cannot be counted towards indefinite leave to remain. Now, coming back to the question, retained right of residence, you will have to show that marriage has lasted at least 3 years and couple has lived together for 12 months. In this case, time frame taken is from the date of marriage. It's not from the date of visa, which could be after the date of marriage, but time frame will be starting from the date of marriage for 3 years. Any part that is before the date of marriage, which is as cohabitation or even if it's in a durable relationship, will not be counted towards retained right of residence. So, answer to your question, unfortunately, anyone who has retained right of residence, anyone who has a visa as an extended family member cannot qualify for retained right of residence, even if they are granted residence card.
Okay. And what if someone has been issued an extended family member visa and then they get issued a family member visa? Can they combine the years together to plug up 5 years and apply for indefinite leave to remain?
Interesting scenario. If they are given residence card on the basis that they're extended family members, and let's say after a year or 2 years they get married, so the applicant or the residence card holder is now a family member of an EEA national, then they can combine periods from the date they were first issued a residence card as an extended family member. From that date only, they cannot add any period that is prior to residence card being issued as an extended family member. So they can combine time frame from the date of residence card as an extended family member 5 years onwards and apply for indefinite leave to remain. But any period that is prior to residence card being issued cannot be combined towards indefinite leave to remain.
Okay, thank you. Now moving on to the final inquiry that I've got. We have received a lot of questions on whether they can make an application on, stateless applications for children under the age of 5 and children who have reached the age of 5. Can they make applications on the basis that they are stateless?
Well, this is one of the cases we have discussed few times in this program now. There is, I think, it's a clear scenario is very clear. If someone is age 5 and above, for example, is an Indian national or a national of a country that requires birth of a child to be registered with the requisite consulates, posts outside of that country, and without that child will not be considered a national of that country. In that case scenario, it's very clear now that if you make an application as a stateless child, nationality will be granted to the child. On the other hand, if child is less than 5 years, Then we have a case that came in some time ago after MK, which was in 2016, I believe, 17. Um, this case came in not too long ago. Is JM Zimbabwe. Now, what this case discusses is whether anyone who is under the age of 5 will qualify under the same circumstances, will qualify for leave to remain in the UK under the immigration rules. Relevant immigration rules are Rule 401 to 403. Now, if child qualifies under these immigration rules, then leave to remain will be granted to the child. But there is a caveat. Immigration rules have an additional requirement that it needs to be proven that child is not admitted to their country of origin or country of origin of their parents. Now, this is where the difference comes in from Nationality Act and immigration rules. There is no such requirement under the Nationality Act, so child will be able to obtain citizenship if child is 5 years and above, because to qualify for citizenship, child needs to be stateless for 5 years. But any child who is under the age of 5, child, in addition to showing that child is stateless, which is a requirement under the immigration rules, child also needs to show, or parents also needs to show that child cannot be entered into their country of origin, so they cannot actually obtain citizenship of that country even if they try. So this is an additional thing that needs to be proven. Now, Secretary of State's position is very clear. If you are an Indian national, for example, even though registration is required, but eventually you are able to get an admission into country of your parents' origin in case of a child. So therefore, children do not qualify under the immigration rules. But this case specifically mentions that if you can provide evidence or show that it's not in practically possible for the parents to obtain citizenship for the child in order for the child to enter their country of origin, then in that case scenario leave should be granted. At the moment there is no specific case law that addresses this issue other than what we have just explained. So we will have to leave it there, but as case law develops, we will come back and address this issue again. So anyone who has a child who is an Indian national, Zimbabwean national, for example, under the age of 5, as long as they can obtain evidence that they cannot practically obtain citizenship for the child, Indian citizenship or Zimbabwean citizenship, they can make this application under the immigration rules.
Right. That was actually the last inquiry. Thank you, Ais, for answering. Is there any online inquiries?
Yes, there are quite a few. It's just following up from the previous nationality question we answered. Person has come back to and said that child, at the time of the birth of the child, both parents had indefinite leave to remain. But in that case, child is a born-based citizen, so child you can simply apply for a passport, which is a travel document. It's an overseas passport application. You can make that application for the child, and once it is granted, of course, child can travel back to the UK. We've got another question. It says, the mother has her BRP curtailed and has British children. She also has failed to renew her leave to remain. It is not clear from the questionnaire whether mother is still in the UK, was BRP is curtailed, or she has left the UK. She has, and if her British children, they are with her or not. But we'll discuss both the scenarios. If mother is within the UK and children are with her, she can make an application as a primary carer of the child. If children are not with her, let's say children are with their father, mother still can make application on the basis we've discussed as an access to child application she can make, as long as she can show that or prove she has access to see her children who are British citizens. In case mother is outside of the UK and children live with her and children are British citizens, she can still make an application as a primary carer of these children, but that application it'll be very difficult to show that there are insurmountable obstacles. She cannot have her family life with her children outside of the UK when she is actually continuing with her family life outside of the UK. So it'll be a very difficult case scenario, but she can make that application in the Human Rights Act. If children are not with her and she is outside the UK, if she can obtain right to access via court or via agreement with the father, she can make an application to the entry clearance officer to come to the UK and in order to see her children. She also needs to meet other requirements in terms of she has enough social financial connections back home, and she will come back to her country of origin, but she can make an application on the basis that she wants to see her children, as long as she can prove that it's not viable for the children to visit her every time. Yeah,
Thank
that's
you.
it. I think this is all we had for today, and this is all the time we had for today.
So we would like to apologise if any of your live inquiries were not answered today. However, do feel free to give us a ring if there is any query that you may have. But until then, see you next time. Thank you so much, Awais.
You're